The singer has the West Coast case transferred from state to federal court, and Garth Brooks wants the California rape case dismissed and handled in Mississippi. After the We Shall Be Free singer's rape lawsuit against a former stylist and makeup artist for himself and Trisha Yearwood was transferred from California state court to federal court, Garth Brooks didn't waste any time in coming up with his next move. Brooks and his solicitors from O'Melveny and Myers have filed a 17-page move to dismiss in the U.S. District Court Central District of California, stating their desire to get Jane Roe's West Coast case closed as soon as possible. On the morning of December 9, they have asked to appear before Judge Michael W. Fitzgerald in downtown Los Angeles for a hearing. Brooks named the former employee in a document filed in federal court in Mississippi on October 8. In her graphic and unspecified damages-seeking October 3 filing in L.A. Superior Court, the former employee claimed that the Friends in Low Places singer had attacked her in a way that was extremely painful and traumatic. Brooks believes he is entitled to sexual gratification when he wants it, and using a female employee to get it is fair game, said Doug Wigdor, Jane Roe's attorney, who claimed that Brooks began abusing her in 2019 by groping her constantly, making offensive comments, and more because he knew how much she needed work. Brooks said the case was a shakedown to force him to write a check for many millions of dollars, rejecting the charges and the assertion that his prior filing in Mississippi was a blatant attempt to further control and bully his sexual assault victim by using his multimillionaire resources to game the legal system. Reminiscent of the first anonymous lawsuit that Brooks himself filed in mid-September, the country singer is now requesting that Jane Roe resubmit her complaint as counterclaims and that all proceedings be shifted to Mississippi. Procedural as the thunder rolls, Brooks' lawyers Eric Amdurski and Megan K. Smith, together with Daniel Petroselli, who seems to be hovering around big names in big studio cases these days, placed their manicured thumb on the federal rules of civil procedure precedent. To cut a long story short, the Brooks team maintains that Jane Roe's October 3 lawsuit in the Golden State and its client's September 13 filing in the Magnolia State constitute duplicative litigation.